Carlos got a call at 6 in the morning. His wife told him through tears that ICE had taken his father from outside their apartment. No warning. No time to say goodbye. His father was somewhere inside the immigration detention system, and Carlos had absolutely no idea where, no idea what to do, and no idea if he would ever see him again. If your family member was detained by ICE, you are probably terrified right now, and every minute feels like it matters, and it does. I'm an immigration attorney, Magdalena Cuprys, and I handle detention and bond cases across Florida. Here's exactly what to do starting right now. The immigration detention system in this country is enormous, and it moves fast. People are transferred between facilities without warning. They lose access to phones for days. Families have no idea where their loved ones are. And ICE does not make it easy to find out. Here's what I need you to hear right now. The moment your family member is detained, the clock starts. There are deadlines in detention cases. Decisions get made quickly, sometimes without proper notice. The faster you act, the better your position is. So let's go step by step. Step 1, find out where they are. The absolute first thing you need to do is locate your family member. ICE has an online detainee locator on their website at ice.gov. You will need their full legal name, country of birth, and either their date of birth or their alien registration number, which is the number that ICE assigns them, which is sometimes called the A number. If they do not appear in the locator yet, do not panic. It sometimes takes 24 to 48 hours for someone to be fully processed into the system after arrest. Keep checking. Also, call ICE's Enforcement and Removal Operations line directly and call local county jails in your area, because ICE sometimes holds people in local facilities while arranging transfer to a dedicated ICE facility or an immigration detention center. Step 2, get their A number. The alien registration number, the A number, like the letter A, is your most important tool for navigating this system. Every person in immigration proceedings has one. It appears on prior green cards, prior work permits, court notices, and old visa documents. If you can reach your family member by phone from the detention center, have them give you that number and repeat it so that you can write it down. Once you have it, you can track them in the system, hire an attorney to represent them, and stay connected to their case. Step 3, understand what a bond hearing is. Not everyone in immigration detention qualifies for bond, but many people do. And this is where having an attorney makes a real measurable difference in outcomes. A bond hearing is a court appearance before an immigration judge. At that hearing, the judge decides whether your family member can be released from detention while their immigration case is pending, and if so, at what cost. The government will argue against release. They will say your family member is a flight risk. They will argue they are a danger to the community. Your family member needs someone in that courtroom fighting back. What happens at the bond hearing? At the bond hearing, your family member or their attorney presents evidence that they are not a flight risk and not a danger to the community. This means ties to where they live, how long they have been in the United States, their family relationships, their work history, their community involvement, whether they have ever missed an immigration hearing or any other court date before matters. The immigration judge sets a bond amount. If your family can pay it, or if you use a bond company that specializes in immigration bonds, your family member can be released while their case continues in immigration court outside. Bond amounts in immigration cases can range from $1,500 to $25,000 or more, depending on the judge, the facility, and the individual circumstances. If bond is denied, or if the amount is too high, there may be an option to appeal the bond decision to the Board of Immigration Appeals. What if they are subject to mandatory detention? Some people are legally required to be held in detention regardless of individual circumstances. This typically applies to people with certain types of criminal convictions or people who have prior orders of removal. These are called mandatory detention cases. If your family member is subject to mandatory detention, that does not mean all hope is gone. There is a legal remedy called the habeas corpus petition filed in federal district court that challenges whether the detention itself is lawful. These are complex cases that require an experienced attorney, but they exist and they have succeeded. What about their immigration case? While your family member is in detention, their immigration case is still moving, often faster than cases for people who are not detained. There will be court dates. There may be offers of voluntary departure from immigration judges or from the government. Your family member should not agree to voluntary departure, should not sign any documents, or make any decisions about their case without first speaking with an immigration attorney. Voluntary departure can sound better than a removal order, but carries its own consequences. A removal order can create bars to future immigration benefits that are very difficult to overcome. So what can you do from the outside right now? Gather their documents, their work permits, prior court notices, any immigration letters, any evidence of their history and presence in the United States. You can check for upcoming court dates by calling the Immigration Court's automated case information line at 1-800-898-7180. You will need their alien number to do that. If you are able to put money on their commissary account at the detention facility, that is also wonderful. Detention is a difficult environment, and commissary funds allow them to access basic necessities, phone calls, and some degree of normalcy. And please, talk to an immigration attorney who handles detention and bond cases. Even a single consultation will give you a much clearer picture of what is possible and what the realistic timeline looks like. You are not powerless. I know this feels impossible. I know you are scared for someone you love. But people get out of ICE detention every day and every week. Bonds do get set. Appeals do succeed. Cases get won. It is not easy and it is not fast. But the system has pathways, and having someone who knows those pathways on your side matters enormously. Your family member being in detention right now does not mean this is over. It means you need to move fast and get help. If your family member is in ICE detention right now, please do not navigate this alone. Talk to an immigration attorney who handles bond and detention cases, someone who knows how these facilities work and how to fight for release. My firm, Serving Immigrants, handles detention and bond cases across Florida. Drop a comment below. Were you able to find your family member using the ICE Detainee Locator? Your question may help someone else watching this. And subscribe for more videos that give you real answers.